Visualize an industrial iron cage, heavy bars, riveted steel, and a massive locking mechanism designed to contain a living, voracious force. That creature is government power. We traditionally view the Constitution as a grant of rights, as if it were a dispenser of freedom, but its structural purpose is restrictive. The Constitution is a container. It is the cage, built to restrain the creature so it cannot devour liberty, property, and the future. If the Constitution is the cage restraining power, what is it sitting on? A cage without a foundation floats. A floating cage is inherently unstable. It can be tilted or overturned by the creature inside. The entire structure shifts. This inquiry is not a political debate over policy. It is an examination of structural physics. Just as gravity determines whether a bridge stands or collapses, the authority of government operates under laws just as rigid. Law precedes government. Because the Constitution creates government, it follows that something must precede the Constitution. We are looking for the granite beneath the cage. If we cannot identify the foundation, the structure of authority collapses. Without granite, iron bends. The distinction between lawful enforcement and mere violence disappears. To find this granite, we must go back to 17th century England and the doctrine of the divine right of kings. At the time, the king's will was treated as law because it was presumed to reflect divine will. Sir Edward Coke, Chief Justice of the King's Bench, reframed this architecture. He declared that the king is under God and the law. Power does not create law. Law restrains power. This forces a chronological reckoning. If a ruler is subject to law, that law must exist before the ruler governs. It exists before the office was created and before any authority was exercised. We see this chronology in the American preamble. The phrase, "we the people," is not ornamental. It reflects a delegation. The people are the principals, the government is the agent, and the Constitution is the written instrument of that agency. Delegation presupposes ownership. I can authorize someone to manage my property, but I cannot authorize them to dispose of a neighbor's property. I have no title to it. You cannot delegate what you do not possess. Therefore, the people must have possessed lawful authority and rights prior to the act of delegation. If they did not, the Constitution is a transfer of nothing. This prior source is not a statute or a vote. It is the rule of right discoverable by reason, an immovable standard that exists whether it is acknowledged or denied. This is the granite. This is natural law. Without this inherent rule of right, the delegation is fiction. And if the delegation is fiction, the cage is completely unsupported. Natural law provides the principle, but the structure requires precise constraints to transfer that weight. These are legal maxims, the pillars of the hierarchy. Maxims are the axioms of jurisprudence. They are not suggestions. They are the necessary conditions that allow law to function as law. In geometry, you accept as a starting point that parallel lines do not meet. From that fixed truth, you build. In law, maxims are the self-evident truths that serve as the bones of reason. Take the maxim, "No man may be judge in his own cause." If the accuser is also the adjudicator, justice dissolves into personal preference. This is a structural necessity. Without impartiality, the framework of a trial collapses. Or, derivative power cannot exceed its source. If the people do not possess a certain power, they cannot grant it to an agent. The stream cannot rise higher than the spring. Violating these axioms isn't a policy disagreement. It is a structural failure. If a bridge is built with wrong load calculations, the bridge fails regardless of the builder's intentions. Maxims anchor the Constitution to the granite. Without these bones of reason, power is free to redefine its own limits. The Constitution, the written trust instrument, sits on top of these pre-existing pillars. It does not create rights. It organizes delegated power under pre-existing law. Above the Constitution stand statutes and regulations. These derive their authority entirely from the cage below them. They are the highest rungs, but they are also the most dependent. This vertical dependency is absolute. Nothing lower in authority can override what sits beneath it. Authority flows downward from natural law. Reason tests upward from the application of force. This is not just theory. It is the text of Article 6. The Supremacy Clause defines what qualifies as the supreme law of the land. Its qualification is precise. It does not say all laws are supreme. It says laws made in pursuance thereof share in that supremacy. In pursuance thereof is a structural filter. It requires conformity to the Constitution. If a statute stays within the delegation, it is supreme. If a statute exceeds its delegated powers, it is no longer in pursuance of the Constitution. It detaches from its source and loses all lawful authority. A common misconception holds that a statute is supreme simply because it was printed in a codebook. In reality, its authority is strictly conditional upon this vertical hierarchy holding it up. To secure this hierarchy, the structure employs an operational mechanism, due process. Due process is not a remedy provided after the government acts against a person. It is not a court date you receive as an afterthought to an arrest. Structurally, due process is a condition precedent. It is a prerequisite gate that must be opened before lawful force can ever attach to a citizen. Opening this gate requires two specific verifications: proof of authority through lawful delegation, and proof of reason through alignment with the maxims. The Fifth Amendment's guarantee of due process is an inheritance from the Magna Carta's law of the land. By constitutionalizing this phrase, the founders bound the government to a recognizable standard of law. Law of the land refers to settled, pre-existing principles and maxims. It is a term of limitation, preventing the legislature from redefining rights at will. If jurisdiction does not attach through due process, the government action has no legal weight. The gate remains locked. Without due process as a mandatory condition precedent, the distinction between lawful authority and violence disappear. Force becomes the only rule. When an enactment attempts to contradict a foundational maxim, the structure collapses. The load-bearing beam fails, and the statute plummets into the void. The term for this failure is void ab initio, void from the beginning. Unconstitutional laws are not flawed law, they are non-law. Because authority must flow from higher law, an act that contradicts that hierarchy never possessed lawful authority in the first place. In Norton v. Shelby County, the court was absolute. An unconstitutional act is not a law. It confers no rights, it imposes no duties. It is, in legal contemplation, as though it had never been passed. This determines the pedigree of force. Lawful enforcement can be traced, rung by rung, to the granite. Violence is force without that chain, even if it carries a seal or a badge. To preserve this structure, we must actively audit authority. Every exercise of power must pass 4 structural tests. First, trace the delegation. Locate the specific constitutional grant. Second, test the scope. Derivative power cannot exceed its source. Third, test the maxims. Verify the bones of reason, such as impartiality and the right to be heard. If a maxim is breached, the integrity of the act is compromised. Fourth, verify due process. Ensure jurisdiction was established before force was applied. The constitutional cage only restrains power if we refuse to grant unlawful force the dignity of law. The structure stands only as long as we test authority by reason.